there's nothing easy about this case, and there's nothing easy about a decision like this, especially when you know the individuals involved and have had, I would say, a pleasant working relationship with them, even though many times they do not, we do not end up agreeing. But in the end, I have to look at the evidence and the law and the rules in this case and set aside some personalities, maybe frustrations some people have had on one side or the other. And for me, this is a basic personnel matter. Whether Jane Doe is an intern or a volunteer, what rights do people in that situation have when they file a whistleblower complaint with the Idaho legislature? And what are the obligations of a legislator, since legislators are essentially administrators of the House of Representatives who elect one person to manage day-to-day activities? The issue, in summary here, is the rights of an employee intern to make a claim of violation of law and improper conduct, and whether the response by a person in power, in this case a legislator, is or is not conduct unbecoming a member of the legislature. And this involves a consideration of Idaho law, Mason's Rule 4.2, as well as the evidence presented at our hearing. First, I note, there is no rape shield law in Idaho. So other states have enacted them, but Idaho has not. So we cannot look to that for guidance. There is, however, a Idaho whistleblower statute, which provides protection for public employees who report to administrators any, quote, suspected state law violations. And in Section 3 of the statute, it does prohibit adverse action against an employee. Whether the Jane Doe is an employee is not clear. She was, many have called her an intern, and Representative Giddings believes she was a volunteer. But certainly, and so they may not be specifically within the statute, but certainly the statute gives us some guidance regarding the public policy of the state of Idaho with regard to sexual harassment complaints which are presented to administrators by public employees. Second statute that may have may be helpful is Idaho Code 675911, which provides for reprisals for opposing unlawful practices. It does appear to apply to the human rights chapter, but and so it may not be specifically applicable to the legislature. But again, it gives us some guidance on what the public policy overall is in the state of Idaho. Now, when there isn't a particular rule or law that is applicable, we look to Mason's 4.2, and under Mason's 4.2, we look to custom, usage, and precedents in determining the standard of conduct. And I do have copies of that if anybody would like one. Let's first talk about the custom, and that's why I was asking questions of the witnesses about the custom in public employment and even in private employment. The custom, we had a testimony from a representative who had spent 30 years in teaching and education administration, testify about the practices at the school districts in which she was involved. We had a former businessman, Representative Vanderwoude, who testified regarding business and in general in the community. And he said that in general in the public, he gave his opinion on what the public generally would find acceptable under these circumstances to look at. All the evidence was that you don't disclose the name of a person who has filed a complaint, a whistleblower type complaint, which is essentially what this is. You don't put their picture on social media. You don't do that if you're involved in the organization. I don't see where I really have a choice but to find that what was done was wrong, because I don't have any evidence to the contrary. I didn't have anybody come into this hearing and say, well, you know, in my business, this is something that we do when we have a whistleblower type complaint. One of the administrators will publish the name, or in this case, publish the picture and an article about it and that kind of thing. There's no evidence. Now, if there is some, it should have been brought, and there were a number of witnesses listed, but then they never, and many of whom were in the room, but then they never testified. So without that kind of evidence, what conclusion can one come to except that, well, doing this is not appropriate for a person in authority under these circumstances. We can also look at precedent, and again, the precedent is that there was an incident in the Senate several years ago, well publicized, where a Senate staffer was sexually harassed. The senator resigned, and even today, Representative Vanderwoude testified he doesn't know who she was. His daughter serves in the Senate, and the name was never even given out in private conversations, that kind of thing, as far as I know. And that's the evidence I have to have, because there's no evidence to the contrary. None. There's no evidence that ever in the Idaho legislature has a person who filed a sexual harassment claim had been publicly exposed in one way or another, publicly disclosed in one way or another. There's just no evidence of that. And so what can you do as a finder of fact, as a committee, but find that the precedent in the Idaho legislature is you don't do it. You don't, there's just nothing, there's no evidence and to the contrary. Now, why should we care? I think this is an issue that needs to be addressed. And I think that the reason behind whistleblower statute, the reason behind disclosure is that we want people to come forward and make complaints, make good faith complaints, but we want them to feel like they're not going to be punished if they disclose, for example, somebody is embezzling money, or suspected of embezzling money, or somebody is improperly using state property, these kinds of things, or sexual harassment.